Welcome to the 2015 Frank Irvine Lecture. Today we are delighted to have with us Adam Liptak, who covers the Supreme Court for the New York Times. His column on legal affairs, Sidebar, appears every other Tuesday. He was a finalist for the Pulitzer Prize in explanatory reporting in 2009 for American Exception, a series of articles examining ways in which the American legal system differs from those of other developed countries. He received the 2010 Scripps Howard Award for Washington reporting for a 5-part series on the Roberts Court. Adam is a graduate of Yale College and Yale Law School. He practiced law at a large New York City law firm and then in the legal department of the New York Times before joining the paper's news staff in 2002. His journalism has appeared in The New Yorker, Vanity Fair, and Rolling Stone, and he has published articles in several law reviews. I have actually seen a draft of a co-authored article he's currently working on, which is excellent. He's the author of To Have and Uphold, the Supreme Court and the Struggle for Same-Sex Marriage. He's a visiting lecturer at the University of Chicago Law School and has taught courses on media, law, and the Supreme Court at Columbia, UCLA, USC, and Yale. Perhaps most importantly, he has the poor judgment to quote me from time to time in his news coverage of the Supreme Court. Today, he's going to talk to us about a new deal for the First Amendment. He'll give his lecture, and then we'll have a little Q&A at the end. So please join me in giving a warm welcome to Adam Liptak.
Thank you, Mike. It's great to be here. Mike is a great student of the Supreme Court, and I read his blog, and you should too, with great care and enthusiasm. It's also wonderful to see Steve Schifrin in the audience, which is apt because my topic is something he's thought a lot about, and I've learned a lot from him. So I have the high honor today of presenting this year's Frank Irvine Endowed Lecture, which was established in 1913 to honor Judge Frank Irvine, a former dean of this law school. In earlier years, this lecture has been given by some of the most distinguished members of the Legal Academy and beyond. This year, I'm sorry to say, you're stuck with me. Newspaper articles, which is what I mostly do, start with a lead. First paragraph. It's meant to be colorful and inviting. It's often an anecdote. And the goal is to draw the reader in and entice her to keep reading your article rather than to flip to the next one. Even though I have a more or less captive audience here, I still feel some reflexive obligation to launch into my topic with a bang, but I'm going to resist the impulse. Instead, I'll tell you that my topic today was inspired by an exchange in a Supreme Court decision on pharmaceutical marketing. Justice Kennedy, writing for the majority in 2011 in a case called Sorrell against IMS Health, struck down a Vermont law regulating pharmaceutical marketing, saying it violated the First Amendment. In dissent, Justice Breyer 3 times hauled out what I think he thinks is the biggest insult you can aim at another justice. He accused Justice Kennedy of Lochnerism, and in particular of First Amendment Lochnerism. He was referring, of course, to the Supreme Court's almost universally discredited 1905 decision, Lochner against New York. And let me quote a passage from the conclusion of Justice Breyer's dissent. He said, "At best, the court opens a Pandora's box of First Amendment challenges to many ordinary regulatory practices that only incidentally affect a commercial message. At worst, it reawakens Lochner's pre-New Deal threat of substituting judicial for democratic decision-making where ordinary economic regulation is at issue." So that's the charge. In shorthand, First Amendment Lochnerism. And I want to examine today what the charge means and ultimately to ask what the limits of First Amendment review of what? Of economic regulation, of commercial speech, of corporate speech ought to be. So perhaps the starting point ought to be to explore why being accused of Lochnerism is such a bad thing, why it has such sting, why that was Justice Breyer's go-to insult. Now, there's no question that by any measure, including empirical ones, Lochner is a leading member of what scholars call the anti-canon of Supreme Court decisions, the ones almost universally dismissed as not only wrong but grievous mistakes, the ones no courts cite as authority, the ones Supreme Court nominees feel free to disavow, at their otherwise opaque confirmation hearings. They don't say anything, but they'll say Lochner was wrong. The ones that only the most contrarian law professors try to defend. Lochner has only 3 real rivals in the anti-canon, and they're doozies. Dred Scott, which held that black slaves were property and not citizens. Plessy against Ferguson, which held that separate but equal facilities were constitutional, a holding rejected in the court's greatest triumph, Brown against Board of Education. And Korematsu, which endorsed an executive order requiring 110,000 Americans of Japanese ancestry to be removed from their homes and confined in detention camps. Dred Scott, Plessy, Korematsu, and Lochner. The first 3 decisions are moral disasters. But Lochner, well, it struck down a law saying bakers could work no more than 60 hours a week. The law was probably a good idea. Whether it was a good idea was almost certainly better decided by legislators than judges. But the Supreme Court's decision striking it down did not engage in the shameful discrimination of the first 3, which left a permanent stain on the nation's history. How did Lochner get such a bad reputation that Lochnerism is among the worst things you can accuse a judge of? To be sure, the case stands for more than an assessment of who is best positioned to decide how long bakers can bake. Lochner is in many ways an emblem, an exemplar of the Lochner era, in which the court is said to have gone badly astray in substituting its judgment for that of legislatures on economic matters. Or, as Justice Holmes said in his dissent in Lochner, the court chose to endorse laissez-faire economics at the expense of competing models. I'm not sure anyone would remember the economist Herbert Spencer but for Justice Holmes's remark that the Constitution, quote, does not enact Mr. Herbert Spencer's social statics. I also don't know what social statics means. In the Lochner era, as opposed to the Lochner case, the court struck down countless laws on wages, working conditions, and unions. The era ended in 1937 with West Coast Hotel against Parrish. But what exactly was wrong with Lochner? The question is important for my inquiry because we cannot evaluate the charge of First Amendment Lochnerism without knowing what Lochnerism means. David Strauss of the University of Chicago posed the question in a 2003 article. Why was Lochner wrong? He sketched out 3 conventional critiques. One is, the usual one, the one you read in newspaper editorials, that Lochner was activist. An activist in a particular sense, and probably the best sense of the word activist, in the sense that it struck down laws enacted by representative and politically accountable bodies. But activism in this broad and simple sense was not what Justice Breyer was accusing the majority of. Justice Breyer, like all modern justices, is perfectly content to substitute his judgment for that of legislatures in some cases. Think back on the last 2 days of the 2013 term. On the penultimate day, on the next to last day, 5 justices voted to strike down a key provision of the Voting Rights Act, a decision Justice Ginsburg later called stunning in terms of activism. The next day, Justice Ginsburg and 4 other justices voted to strike down the Defense of Marriage Act. In dissent, Justice Scalia protested that, quote, we have no power under the Constitution to invalidate this democratically adopted legislation. Each side accusing the other of activism in the sense I just meant. Only Justice Kennedy was in the majority in both cases. So there must be more to Justice Breyer's objection in the pharmaceutical case than the general idea that Lochner was activist. The second critique of Lochner sketched out by Professor Strauss does not concern judicial review as a general matter, but one grounded in the enforcement of rights not set out verbatim in the text of the Constitution. Lochner struck down laws based on the right to freedom of contract. You'll search the Constitution in vain for those words. Chief Justice Hughes was famously dismissive of this supposed right in West Coast Hotel. What is this freedom, he asked. The Constitution does not speak of freedom of contract. True enough. But nor does it speak of a right to privacy, to say nothing of a right to abortion, or for that matter, a right to marry. Justice Scalia made this point in an artful and oblique reference to Lochner in his dissent in Lawrence against Texas. The law struck down, the Texas law struck down there, banned gay sex, and Justice Scalia said, it undoubtedly imposes constraints on liberty, So do laws prohibiting prostitution, recreational use of heroin, and for that matter, working more than 60 hours per week in a bakery. He didn't cite Lochner. He didn't need to. Most people got the reference. But Justice Breyer was also not accusing the majority in that pharmaceutical case of relying on a phantom unenumerated right. Whatever freedom of speech means, it is a verbatim phrase in the Constitution and not a penumbra. Justice Kennedy made this obvious point in the pharmaceutical case in characteristically glib fashion. He said, "The Constitution does not enact Mr. Herbert Spencer's social statics. It does enact the First Amendment." That doesn't yet, though, tell you what the First Amendment means to do in this area of economic regulation. The third critique of Lochnerism sketched out by Professor Strauss rests on the idea that there is something particularly illegitimate about invalidating laws to enforce the freedom of contract. That unenumerated right is particularly legitimate, it is said, because property rights are inferior to one's protecting liberty, and particularly the liberty of the powerless, whether enumerated or not. But in recent decisions, the Supreme Court has certainly treated something like freedom of contract, even among parties with vastly different economic power, as a background principle, if not a constitutional right. In 2011, in AT&T Mobility against Concepcion, the court ruled that businesses like cell phone providers and car rental companies can use standard form contracts, those contracts you get, you don't have a choice but to sign them if you want the service, to forbid consumers from banding together in a single arbitration. The effect of the decision was to allow businesses to use contracts of adhesion to bar class actions. And last month, the court ruled that a temp agency was not required to pay workers at Amazon warehouses for the time they spent waiting to go through security screenings after work. The workers said that the process, meant to prevent theft, could take as long as 25 minutes. Justice Thomas, writing for the court, said the Fair Labor Standards Act did not protect the workers. Their arguments, he said, quote, are properly presented to the employer at the bargaining table. So what was Justice Breyer driving at? What sort of First Amendment judicial review amounts to Lochnerism? When is it inappropriate for the court to say that an economic law regulation violates the First Amendment? The first hint in the pharmaceutical case was a citation to then Associate Justice Rehnquist's lone dissent in 1980 in Central Hudson, the seminal commercial speech case. In a passage quoted by Justice Breyer in the pharmaceutical case, Justice Rehnquist said, "The court's decision today fails to give due deference to the subordinate position of commercial speech. The court, in doing so, returns to the bygone era of Lochner against New York, in which it was common practice for the court to strike down economic regulations adopted by a state based on the court's own notions of the most appropriate means for the state to implement its considered policies." A second passage in that dissent, not quoted by Justice Breyer, reminded readers that the very idea of First Amendment protection for commercial speech was a very recent innovation, established in 1976. It also used the metaphor of a Pandora's box, the metaphor Justice Breyer would borrow in that pharmaceutical case. "I remain of the view," Justice Rehnquist wrote, "that the court unlocked a Pandora's box when it elevated commercial speech to the level of traditional political speech." Justice Rehnquist was also the sole dissenter in the case he was referring to there. He did not cite Lochner by name, but he certainly seemed to allude to it, replacing Herbert Spencer with Adam Smith. "While there is much to be said for the court's observation as a matter of desirable policy," Justice Rehnquist wrote, "there is certainly nothing in the United States Constitution which requires the Virginia legislature to hew to the teachings of Adam Smith in its legislative decisions regulating the pharmacy profession." So hold that first thought. It may be that First Amendment Lochnerism turns on the content of the speech sought to be regulated. If it is commercial speech, additional or perhaps total deference may be owed to the legislature. Or perhaps we're talking about a subset of commercial speech, as Justice Breyer suggests elsewhere in his dissent in the pharmaceutical case. Perhaps we are talking about speech that only indirectly affects economic matters. No. Perhaps we're talking about speech that is only indirectly affected by economic regulation. So here's how Justice Breyer talked about this subset of commercial speech. The court also normally applied a yet more lenient approach to ordinary commercial or regulatory legislation that affects speech in less direct ways. In doing so, the court has taken account of the need in this area of the law to defer significantly to regulatory judgment. So perhaps there are two preconditions to First Amendment Lochnerism. The speech must be commercial, and the regulation must be part of what Justice Breyer called ordinary regulatory program. And then Justice Breyer drew these two strands together with a third reference to Lochner. Given the sheer quantity of regulatory initiatives that touch upon commercial messages, the court's vision of its reviewing task threatens to return us to a happily bygone era when judges scrutinized legislation for its interference with economic liberty. History shows that the power was much abused and resulted in the constitutionalization of economic theories preferred by individual jurists. Okay, now so far I've referred from telling you about the pharmaceutical case, Sorrell against IMS Health, the one that drove Justice Breyer into a Lochner-spewing frenzy for fear that I would bore you even more than I have done so far. But it's worth a look, at least partly because some commentators say its revision of commercial speech, this is a case you've probably never heard of or thought about, is more dangerous and more consequential than the First Amendment vision of Citizens United. One of them, Tamara Piety, criticized the decision across a dimension largely unexplored by Justice Breyer. She focused not on the subject matter of the speech or the nature of the regulation, but on a third factor, the identity of the speaker. She said, treating global pharmaceutical companies as if they were embattled, underrepresented minorities. Let me try that again. Treating global pharmaceutical companies as if they were embattled, underrepresented minorities risks trivializing the real life and death struggles of plaintiffs who are in fact relatively powerless, and elides the court's exercise of its counter-majoritarian power on behalf of the powerful. So this case, the Sorrell case, was about a Vermont law that prohibited some but not all uses of information collected by pharmacies in filling prescriptions. Pharmacies obviously get a lot of data about us when we go to get a prescription. They collect it, and they are required by the government to collect this information. So Vermont had a law limiting what could be done with the information. So did Maine and New Hampshire. Having collected the information, the pharmacies, which are businesses, sought to monetize it. How could they make money out of it? And they had willing buyers, notably data mining companies, that in turn wanted to sell the information to pharmaceutical companies. The information was valuable to the companies. If they knew which doctor was prescribing which drugs, they could tailor their marketing efforts, which were intensive and generally performed in person by quasi-salespeople known as detailers. Now, this was not information that was personally identifiable. So your first impulse is to go, wait a second, they're selling information about my private prescriptions? Not exactly. The personally identifiable information was stripped out, but nonetheless, you could tell whether one doctor was prescribing a lot of a generic drug, another a lot of a brand name drug, and this was information enormously useful in marketing efforts that pharmaceutical companies tried to undertake. Now, it's true that other uses of the same data was allowed. So the pharmacies could sell the information to law enforcement, to insurance companies, to journalists, and drug companies remained free to market their drugs in more indiscriminate fashion. They could go to every doctor and say, you ought to be using my brand name drug. But it's really useful to them to know that a particular doctor was leaning heavily on, say, a generic drug. State lawmakers justified the laws as an attempt to ensure accurate and balanced presentation, notably in comparisons of generic and brand name drugs. The Vermont legislature, in what may have been a misstep given current First Amendment doctrine, explained that it enacted the law because, quote, the marketplace for ideas on medicine safety and effectiveness is frequently one-sided. So here we have the government using its regulatory power to sort of shape what kind of speech would be coming out of the mouths of these pharmaceutical companies. But the Supreme Court has often been wary of governmental efforts to level the free speech playing field, although usually in the political, not the commercial arena. In a decision the Supreme Court ended up affirming, a divided three-judge panel of the Second Circuit struck down the Vermont law. Judge John Codal, a district court judge sitting by designation, wrote that the statute seeks to alter the marketplace of ideas by taking out some truthful information that the state thinks could be used too effectively. In dissent, Judge Deborah Ann Livingston said that Vermont had made an eminently reasonable legislative judgment. I am unwilling, she said, to accept the majority's conclusion that such business operations have an inherent right to invoke the First Amendment as a shield against reasonable regulation, simply because their businesses deal in dry information rather than dry goods. The Supreme Court majority, 6 of them, Justice Kennedy writing, joined by the Chief Justice and Justices Scalia, Thomas, Alito, and Sotomayor, thought otherwise, using classic First Amendment doctrines developed in other areas, notably content discrimination, to strike down the Vermont law. Here is a particularly ripe sentence from Justice Kennedy's opinion. Many are those who must endure speech they do not like, but that is a necessary cost of freedom. It's a necessary cost of freedom to listen to the pharmaceutical marketing guy who knocks on your door if you're a dentist or a doctor. Reading the opinion, Professor Piety wrote, one might be forgiven for thinking that this was a civil rights case rather than an issue of regulated pharmaceutical sales practices. A couple of weeks ago in The Atlantic, Garrett Epps identified the legacy of Sorrell. Justice Kennedy had rested his analysis on the contention that the Vermont law was content-based, triggering what turned out to be, as it usually is, fatal, strict scrutiny. The statute disfavors marketing, Justice Kennedy wrote, that is, speech with a particular content. Professor Epps said this drained the concept of content of meaning. The word content, he wrote, has become unmoored. Marketing is not a subject. It's an economic activity to be regulated as needed by the specific market it involves. Kennedy's foggy vision of content will, very soon, take us to a place where government can't regulate advertising at all. In focusing on pharmaceutical companies as speakers, the Sorrell decision shifted the focus of commercial speech in a second way. First Amendment protection for commercial speech was initially justified as aiding consumers, that is, listeners rather than speakers, in obtaining truthful information about prices and products. The shift to solicitude for speakers, even if corporate or commercial, one that partly also animates Citizens United, may be the key move, the one that could serve as the organizing principle of First Amendment Lochnerism. The First Amendment, as Professor Schifrin has pointed out, used to be a left-wing project, one concerned primarily with protecting political dissent. There followed, as Bert Newborn wrote in his recent book, Madison's Music, something he called the First Amendment era of good feelings, starting in the Civil Rights era and culminating in the flag-burning cases in 1989 and 1990, where the Supreme Court found a First Amendment right to burn flags. In that era, justices appointed by both Republican and Democratic presidents started to protect all kinds of speech, categorically, close to absolutely, and that speech included not only speech from dissenters, powerless dissenters, but also rich people seeking to influence elections and companies eager to advertise. By 1990, Professor Newborn wrote, some progressives began to suspect they had made a bad First Amendment bargain. The cost of protecting flag burning, they saw, was amplifying the power of the rich and of corporations. The bargain was Faustian, Professor Newborn wrote, far more likely to reinforce the status quo than to destabilize it. The Roberts Court era in many ways confirms this. The court has a reputation of being exceptionally supportive of the First Amendment. Leading scholars and practitioners have called the Roberts Court the most First Amendment court in American history. The public, you, may well share this opinion, based mostly on a large handful of colorful cases, including ones protecting hateful protests at military funerals, the makers of violent video games, the distributors of materials showing the torture of animals, people who lie about having received military decorations, and abortion counselors and abortion protesters. But a 2012 study challenged that impression. So we have these colorful and important cases, and cases which do send a message that we have to tolerate quite a lot of ugly speech. This 2012 study challenged that impression. It said the court is hearing fewer First Amendment cases and is ruling in favor of free speech at a lower rate than any of the courts led by the 3 previous Chief Justices. And that was including, at the time, 6 campaign finance decisions. Erwin Chemerinsky, reviewing the phenomenon in the Arizona Law Review, wrote that what really animates the Roberts Court is a hostility to campaign finance laws, much more than a commitment to expanding speech. The court, he wrote, has a dismal record of protecting free speech in cases involving challenges to the institutional authority of the government when it is regulating the speech of its employees, its students, and its prisoners, and when it is claiming national security justifications. In 2010, for instance, 5 months after the Citizens United decision, the court ruled in Holder against Humanitarian Law Project that the First Amendment did not protect even benign assistance in the form of speech to groups said by the government to have engaged in terrorism. The Roberts Court's overall record, Professor Chemerinsky wrote, suggests that it is not a free speech court at all. Tim Wu, who clerked for Justice Breyer, teaches at Columbia, and is not the lieutenant governor of this state, summarized where all of this leaves us in the New Republic, by which I mean the old New Republic, in 2013. Professor Wu wrote, "Once the patron saint of protesters and the disenfranchised, the First Amendment has become the darling of economic libertarians and corporate lawyers who have recognized its power to immunize private enterprise from legal restraint." Now, the examples of this are not fanciful, but rather routine, and the new First Amendment arguments are routinely successful. Tobacco companies say that requiring them to provide graphic health warnings violates their First Amendment rights. Standard & Poor's says its ratings, which contributed to the financial crisis, are immune from lawsuits thanks to the First Amendment. Pharmaceutical companies say their salesmen, second pharmaceutical case, cannot be prohibited from urging doctors to make off-label uses of their drugs. Airlines object to laws requiring them to disclose the full price of tickets, including taxes. Mining companies and others are challenging an SEC rule requiring firms using so-called conflict minerals to investigate and disclose the origin of those minerals. Meat producers have challenged the requirement that they disclose where an animal was born, raised, and slaughtered. Internet and cable companies routinely turn to the First Amendment to challenge regulations. All of this suggests that the law might want to be attentive to not only distinctions between commercial and political speech, but also between powerful speakers and powerless ones. That distinction is in tension, of course, with the court's campaign finance decisions, which have rejected the government's efforts to level the playing field for speech. But it is not precisely the same thing to announce that you are suppressing some speech to make sure other speech is heard, on the one hand, and to resist allowing searching judicial review sought by the powerful of democratically accomplished economic regulation, on the other. That distinction finds support, of course, in the Caroline Products footnote, and also in West Coast Hotel, which spelled the end of the Lochner era, partly based on what Chief Justice Hughes called the inequality in footing of the parties. So I started by telling you that a good newspaper article starts with a strong lead. I failed to deliver. A good newspaper article should end with a kicker, something pungent that sums things up. I confess, I don't really know where all this leaves me. I practiced First Amendment law for 14 years as a lawyer, and I drank the Kool-Aid. I then believed, and I guess I still believe now, that speech is so important that we should be very wary of government regulation. But I guess if there's a place to, and I'm also not crazy about making distinction based on tiers of scrutiny or Justice Breyer's somewhat European approach of proportionality, of weighing the interests on both sides. But I do think that there is something troubling we should all think about economic regulations being routinely struck down on First Amendment grounds in ways that do resonate with the Lochner decision. And so I picked the title of my talk from a nice phrase that Cass Sunstein came up with in 1993. He asked whether it's time for a new deal for speech. As the New Deal ended the Lochner era, perhaps the right response to First Amendment Lochnerism is a new deal for the First Amendment. Thank you very much for your attention, and I'm happy to answer your questions about pharmaceuticals or the Supreme Court or the New York Times or whatever else is on your minds.